Hi, and welcome everyone to the English Show. My name is Stephanie, and this is episode 13. I am accompanied by the world's most tropical attorney, Gil.
Thank you.
How are we today?
I'm doing great. Welcome to the English Show, episode 13.
I love that you're exceptionally tropical today because I came in full snow gear.
It
like
is.
The rest of the United States.
Most of the U.S. is very cold. Here, Miami was actually chilly.
Exceptional.
Yeah.
We're complaining that it's 60 degrees. So what? 15, 16 degrees. So we're complaining about that, just so you know. But the rest of the United States is basically under snow.
They are.
And that's why we're the tropical attorneys.
That's it. So, Steph, we're going to start today. Obviously, we're going to get your questions. To reiterate, different style of show. Yes, Q&A, but we like to be topic based and kind of going over different topics and just to kind of lead the way a little bit. If you have questions, please feel free to leave the comments and we will get to the questions. But let's get into it a little bit.
Let's go.
I'm sorry, do we have news?
We don't have news because we kind of talked about the 75 countries last time. We talked about there is an increase in fees.
Premium, definitely.
Upcoming March 1st, 2026. Those fees will be changing slightly. It's really adjusting for inflation, so it's not very significant. For instance, premium for I-140s and I-129 is jumping from $2,805 to $2,900, something like that. So the fees are going up. If you want to avoid that fee hike, file before March 1st, but it really isn't that significant. I think that's the only really breaking piece of news that's USCIS related.
Yes.
Yeah. And DOS related.
We read an interesting article this morning.
Oh, gosh.
Let's talk about the article we read.
Okay. The one I sent?
Yeah. It was a great article.
It looks like, so essentially they were saying that the administration did a lot of hiring and firing for USCIS officers. So they almost did a huge hiring bump and they had nowhere to put these individuals. So the thing that stuck out in the article to me was the bathrooms were running out of supplies. There were people operating out of closets. So they had this huge hiring bump, but then they also sort of made it, and this is what kind of saddened me a little bit. Instead of looking at people who were career USCIS officers who have gone through many administrations, through every iteration, Democrat, Republican, and everything, and they have the experience, they were choosing to keep USCIS officers on that are more in line with the current administration's policies. They were almost, did you see they were subjecting them to polygraph tests?
Yes.
So they're subjecting these USCIS officers to lie detector tests.
How's that even legal?
I don't even know. The article was crazy, and it was reporting from USCIS officers like whistleblowers, right?
Yeah.
And they were stating, look, for the first time, all these career USCIS officers that have been there for 20, 30, 40 plus years were being fired because they were not in line and they were actually just trying to follow the law versus trying to follow current administration policy.
Yeah.
Which is a little sad.
Yeah. I was saddened by it, to be honest with you. Reading it out, to be fair, I felt bad for the USCIS officers.
Right.
I really did. It wasn't we're fighting immigration on a daily basis. I wouldn't say I'm fighting necessarily, but we're adversaries in the sense that we're trying to obtain a benefit from a client. They're trying to show us how the person doesn't qualify and the back and forth and everything we do. I legitimately felt bad for them reading that. The working conditions, that's not great or ideal. Obviously, that's upsetting, I would say, to most people. But the fact that, somebody gives 25, 30 years of service, they're serving really the public good and United States citizens' interests, like being very careful who they allow into the US, having, obviously their protocols in place, everything like that. And let's be honest, immigration has never been easy.
Ever.
Okay. So I just find it and so that article was basically written by 4 or 5 previous USCIS officers that are no longer with the service. And they gave us good insight into that. I really did feel bad, but it also goes, Stephanie, to something we've been discussing, which is we see a lot of weird things in RFEs, misapplication of the law. At first we were considering if they're doing this on purpose. And I don't think they're doing it on purpose. I think they're doing it because they don't know. They don't know better. It actually it makes me even feel bad for the new people. You just don't know what you're supposed to be doing actually, or what the law actually is. So it also explains a lot of things that have been happening and kind of things we're seeing. One thing they did reference there was, hey, listen, there was so much backup already of work to be adjudicated of cases, and now they got rid of a ton of people. And yes, they did hire more, but these are more that are not efficient in their
And
processing.
people who don't know the policies yet. Like you can't, how long did it take you to have a mastery of immigration law?
Oh, 15 years.
Exactly.
Yeah.
And so it's like, if you're hiring all the people who are career USCIS officers who have been there for 20 plus years and understand the policy well, and they've been adjudicating them, again, no matter the party lines, they've been adjudicating exactly what the INA says, and they've been doing that for 20 plus years, then you're getting all these new people.
Yeah.
They can't get the grasp of immigration law within a couple months. It's an incredibly complex area of the law. So it's upsetting in that sense, but it also, to your point, makes a lot of sense why we're getting decisions in the way that we're getting them and why we're getting RFEs in the way that we're getting them, because they're saying, oh, well, I saw this one thing on ChatGPT, so this must be right. It's like, absolutely not. That is not the way you're supposed to adjudicate those cases. But it teaches us that we need to be a little more educational in our letters. I think that's what I kind of took from that.
Wow, that's such a great point.
Yeah.
That is probably the proper approach with the current administration.
Yeah. You almost have to teach them as you're explaining how you qualify.
In a diplomatic way, in a nice
way.
Yeah, in a nice way, I would say. So, Steph, we're going to talk about an interesting topic today, and that is going to be, can we hit the slides? There we go. O-1 visa today, green card tomorrow.
All right. And by the way, you could do that out of order too. You could do green card first, then O-1A.
Wow, we do that all the time. Yeah. EB-2 and NIW. You know what I mean?
Don't think you have to have one before the other. You could do both, one or none. Well, do one.
But maybe do two.
Both, do both.
So, O1 to EB-1, O1 to NIW, you know, like you said, you could do it now, you could do it later. How do we build those cases? You know, the reality is, number one, you just got the O1. I always tell clients, listen, you just received the O1. Take a break. Take an immigration breather for 6 months. 6 months, I like to reconvene with the client. I like to discuss what potential green card options look like in the future. Current administration included, planning needs to be as early as possible. If you're planning of not having to renew a visa and you want to go directly for a green card in the future, generally speaking, most O1s have the potential to build an EB-2 and NIW.
Yes. And certainly an EB-1.
And certainly an EB-1. You know, traditionally, I probably push clients that are O1B more into an EB-1 and O1A clients, not always, but usually into an EB-2 and NIW. Really, the distinction there is O1B arts really lends itself very well to an EB-1. And I would say also O1A sciences lends itself very much. You know, the medical profession, entrepreneurism, business may lend itself very well to it. So how do you approach that?
Ultimately, as in the consultation, which one we're going to do?
Well, how would you tell a client, this is what you need to be doing to build up to the green card?
Okay, so let's go a business example, right? Business example, we did an O1A based on your own business model. It was actually self-petitioned O1A, and it's your company and you're working for them. What we're going to want to go ahead and show is the level of growth that you've had with the company with the O1A. Again, we could do this almost after 6 months of having the O1A, so it doesn't have to be extremely significant growth, but we want to show that you have a plan of action, right? And we always call that the business plan. So it's, hey, listen, this is the company that I created or I've been working on under my O1A. This is my ideal track of growth. This is the service I want to expand into, and that becomes my baseline for my EB-2 and NIW. My EB-2 and NIW does have to show a minimum of experience or education. So that is something that we do have to keep in mind. That isn't the case in an O1A. Yes. An O1A doesn't have a basic education or experience line. So first, we have to establish that you do meet that minimum criteria of education or experience. And then next, can I show, or how do I show that I have a plan for growth for my O1A business?
Yeah. And then a little bit different approach for the EB-1, not really focused on the future plan, even though that's part of it. That's 5% of an EB-1 versus EB-2 and NIW. Would you say 50%?
Exactly.
Is your future endeavor and what you plan on doing? That's going to be a big indicator. So maybe you'll have a client that has an exceptional career in the past, but they don't necessarily have a project or a proposed endeavor. Even if that person traditionally would be an EB-2 NIW, if it lends itself very well for the EB-1, I think you need to not be afraid of doing the EB-1. EB-1 is still a fantastic option. Just from a numbers perspective, EB-1 approval ratings are relatively higher than EB-2 NIW. Even we are right now, I would say, Stephanie, more conservative with the EB-2 NIW. I'm still kind of gas pedal down with the EB-1. I still feel like I can make some things happen. Really interesting. I was in a we were in a forum there, and I was reading the experience of other immigration attorneys, and they were talking about this goes to somebody's asking a question there regarding what we see like trends and stuff in cases. And it was really interesting because one of the practitioners was saying they had not won a final merits determination EB-1 RFE in 2025.
Wow.
And I was like, whoa, that's not us. Like we have like
that's an odd experience.
Like I either they filed too little EB-1s, but we, it's not my experience generally. Just for a little bit of background, you need to show that you have 3 out of the 10, and after you show your 3 out of the 10, USCIS does something called a final merits determination. Think of it as like, okay, overall, is this person actually extraordinary? Okay, like what? And I don't know. I think we have what I consider a very interesting formula for responding to the final merits determination type of request. So what happens is they'll send you an RFE, or excuse me, it's not even an RFE, it's a notice of intent to deny, annoyed. Everybody hears that, annoyed. It sounds really bad. No, it doesn't.
I like it more than an RFE.
I like annoyed all day long because they gave you the 3 categories, 4 categories, 5 categories, and they're saying in the final merits determination, potentially we don't think that you rise to the level of an extraordinary ability applicant. So in our experience, yes, I mean, that may be denied. However, we're seeing good results with final merits determination.
Really.
So given what I see with that, I'm still, hey, I go for it with some of these EB-1s. Not if it's unreasonable. If it's too much, it's like, no. Those were different times that you could kind of do that type of stuff. Right now, you still want to be conservative. You still want to make sure you qualify. I don't want to have a bare minimum of criteria met. 3 out of 10.
No,
come on.
I need at least 4.
I've heard practitioners tell me, I picked the 3 categories, even if the person qualifies for more. And it's my duty as the immigration attorney to tell USCIS what is the 3 criteria. Not for me. No. Like if we have 7 and 8, like I want to go for it. But you're right, 4, 5, that's a little like that's okay. That makes me feel okay. Like we could do that. If you're borderline, or if you have 3, like you really need to consider sticking to an O-1 for now until you could build that case up a little bit. Again, discussing how to build an O-1 case into a green card case. You mentioned something important, which is continue working in your field and actively working. A lot of these, a lot of O-1 clients, they'll get an O-1 and life is life and things happen, and maybe the kids are in school and entertainment industry might be a little slow, or, things didn't work out how you necessarily thought it would. And you kind of start doing a whole bunch of other little things around your field, still in the field, but not really what got you here. So my advice is that's okay, but we need to get on track, and we need to do as much as we can, even independently, even in a small scale, with what got you here, because that's going to help you with any extension of a visa in the future. But that is really the only way to approach a green card.
Yeah, absolutely. For instance, what I've seen on an EB-1 RFE, which is something, I'll be honest with you, is not something we had seen before, was this individual got press right before he filed his O-1. Okay. And then he got press right before he filed his EB-1. So the press was dated either October 2024 or December 2025, Yeah. And the officer was kind of like, look, like, I'm not dumb. You had this done for the petitions. So now that you realize, they're kind of tracking us, they're being astute about this, consider that even if you're, as Gil says, treading away a little bit because you're doing all these little projects because you need to pay the bills at the end of the day. Still try and remain consistent with at least one major project, maybe every 6 months, that gets some level, that has a date on it, that has maybe some press coverage, that has something that you can point to a date, so that it's all not accumulated. Because what the officer is catching on to is that some people are just saying like, oh man, I need to renew, so let me just take this 1 month to do everything during this 1 month. You kind of need to spread it out. And that also goes to final merits and sustained a claim. Sustained a claim, sustained being the key word there. I need to show that it's continuous. I can't show that I was really good in 1 month in this year and 1 month in that year. And that's something they're catching on to lately.
Yeah, it's such a good point. I would also argue, yeah. I'd also argue, yeah. Where does it say I can't do that?
No, of
you know
course.
what I'm saying?
We
like
had
I'd also,
to,
like I gotta be like,
ultimately.
yeah, I understand. I see your point. But so things to work on, like you mentioned, press. Okay. Definitely want to work on press
and
continuous, ideally. Like, sprinkle it in versus slamming it in at the end, as you indicated, right?
Also, doesn't only have to be in the US.
Please. Yes. Great point. Yes.
Like, it could be in your home country, could be in another country. So maybe you are in the US and you're like, look, I have press contacts back at home because I'm like a big deal, but here I'm just starting out. Get the press done in your home country still.
Absolutely. I think it's also, that's really interesting press. Like so-and-so is making it in the US, doing this, doing that, like I think that's interesting anyways to use in a case. Judging's a big one for an EB-1. I think, you could use judging in EB-2 and NIW as well. You could use it O-1A. Obviously you could use, O-1B, not really. I guess we try to sneak it in there with significant recognition, potentially sometimes, but EB-1 judging
must.
It's a freebie. It's like,
exactly.
If you're not doing its exhibition is a freebie. If you're not proving exhibition of your work, by the way, USCIS clarified this through a policy memorandum stating that exhibition of work is applicable to every single category of profession versus only being in the arts, as traditionally was thought of, like painters and sculptors, okay, as an exhibition in a gallery, for example. No, this applies to everybody. Judging's a freebie. Exhibition is a freebie. So definitely those are ones that we have to have. High salary. Listen, things are tough. High salary is also tough to prove. High salary is tough to argue because the information and the data that's available, I feel like USCIS is fighting us all the way on high salary. You know what I'm saying? Similar to how they fight us on similar web and press and circulation numbers. So even using the Bureau of Labor Statistics information, they're still coming back at us saying, well, that's not a high salary compared to whatever. So high salary could be high salary in the past or high salary in the future. So that would be a good idea to have some sort of future proposed work that you're going to be doing, job offer, project, etc., that specifically states a high salary in accordance with what USCIS requires for a comparable high salary, which is generally speaking an hourly rate versus a yearly salary. Okay. Yeah. But those are things that you could be working on as time progresses. Okay.
The reason also that we say that judging is a freebie is because judging, as long as you have the letter that says, thank you for participating as a judge and for evaluating XYZ, we invited you because you're great at what you do and we want you to continue, being this. A letter is sufficient. Whereas in many of the other cases, one letter is insufficient, right? You have to provide other things. You have to provide other elements. Judging is the only category where that one letter could really win it for you.
Yeah.
That's why we call it a freebie.
Lead and critical role is a great example.
Exactly.
Like you just have a letter. No.
They're not going to give it to you.
They're just not giving it to you just with a letter. So that's actually an excellent point. So what can you reuse from a case? I would, generally I tell people like 90% of that, we got to change some letters and things like that. But a good amount of what's in an O-1 is going to be useful for an EB-2 and NIW. Not always, not every category, O-1A. I feel if you have an EB-2 and NIW already done, is not that difficult to convert it to an O-1A. If you have an O-1A, you still have to do a few extra things there to get it up to an EB-2 and NIW level. So for my science people, for my business people out there that are thinking of doing that in the future, engineers, STEM, etc. Yes, it's definitely possible, but I think it's always easier going from an EB-2 and NIW to an O-1A versus an O-1A to an EB-2 and NIW. So yes, you could reuse most of everything. Well, we kind of covered this. Short term, get to work.
Yeah.
Like, get busy as much as you can. This is an interesting point. Let's talk about recognition that repeats. What type of recognition repeats? What do you think? Festivals?
Festival participation, exactly.
Yeah.
They invited me, if we go back to judging, they invited me to be the judge last year. And so they invited me again to be the judge this year because I did a great job.
Great.
What
else? Like potentially, this is interesting, I would say, in music, royalties. So that's repetitive. Like the point there is something that's kind of generating repetition. I like royalties for TV as well. I think that works. I
had an O-1 client that he was like a project manager, and his company got 3M Best Place to Work. And then the next year, it also again got Best Place to Work. So we used it in the argument that it was like, oh, he's making such an impact and that he's continuing the high standard of the company, basically.
Yeah.
So that was a continuous like award for the company that we were able to impute to the person.
Fantastic.
Repetitive. What else?
How about publishing? I would say publishing, like publishing your work.
Consistently publishing articles.
Yeah.
Maybe.
Yeah.
That's a good one. Or that you have more citations on your articles. Right?
Citations growing. That just grows. That just grows. Google Scholar, it grows on its own. So that's a great example.
Social media presence grows on its own.
Content creation, more views, more likes.
Right.
Very good.
I have a new YouTube plaque this month,
Yes, absolutely.
When are we going to get our next YouTube plaque?
I think the Mill.
All right. So English show, you got to get to work, guys.
Yeah,
the Spanish show has really given us a lot. Okay.
In case you want the Spanish show and you're scratching your head right now, why are these people speaking English? You could see us Thursday at 12 o'clock Eastern Standard Time in Espanol.
Yep.
Long term, it's always be interesting. Thank you, guys. Long term, if you could do anything that is going to have an impact in your industry, that's pure EB-2 and NIW and EB-1.
Yes,
That's just good. Anything you could do that could have an impact. Research papers, publications. You created a manual. You created a software that's used by others. I had a doctor that created a manual on diabetes and on nutrition, and we demonstrated 3 other professionals that utilize it in their practice, and we won original contribution in the EB-1 criteria with that. So there's that goes along. So that goes into long-term thinking. That's not overnight. That type of evidence is not overnight. It does take a while. It's like you said, it's not the, October 2024 press article and December 2025 press article. You understand? It's like, no, you got to think long-term here. Is there a process that you can patent? Is there a product you can patent? Maybe we're not patenting, it's an expensive process. Maybe, or you don't have that. It's a trademark of an idea of, you're a business coach and this is your system that is being implemented and utilized by others. There's a lot of angles to this. What else, Steph?
Okay. So this goes to as far as timing, right? This goes to exactly what Gil was talking about, wherein with this administration, we have to be a little bit more conservative because RFEs are a bit on the rise, not significantly, if I'll be honest, with EB-1s, but with EB-2 and NIWs, they are. So we have to be more conservative in filing concurrently. We kind of are going to, dissuade from it if we can. What we'd like to do is apply for those I-140s as soon as possible. And with, I would say, at least 6 to 12 months remaining on your O-1 minimum, because that gives me a lot of time to play with.
Yes.
If I have 6 to 12 months left on your O-1, I could file that I-140 with premium. I could get a decision. I have time to respond to an RFE. I have time to respond to a NOID if those things come up. And I could, well before your O-1 expires, file that adjustment of status. If we get any concerns with the visa bulletin, we can cover those. So you want to try and do this. This is not something you want to consider with 6 months remaining on your O-1. You want to do it before that. And if you only do have 6 months remaining on your O-1, you really, really need to consider extending the O-1, especially for specific countries.
It's a conversation I'm probably having multiple times a day. I understand everybody wants a green card.
I know. I
currently have an O-1. It expires in August this year. I think I had that twice today, August and September. What do you think about the green card, Gil? It's not impossible, but we're going to have to work 3 to 4 months on that green card, file it. Maybe it gets an RFE. that extends it 2.5 extra months. It's July. We don't have a decision yet.
Right.
Your legal status expires in August. Like, what are we going to do? You know, like I say, you know, I think we have to be more conservative here and say, I'm not saying to look, there's a financial component to this. It's expensive. I understand doing 2 cases is expensive. But we're talking about preserving your legal status in the US first needs to be the priority. The likelihood of success on an extension case is much higher than any other type of case, probably,
Correct.
including an initial filing. You know, and then parallel to that, working on a green card application, that is probably advisable.
And if there's like a financial element to it, maybe you want to consider using that money to pay for the O-1 extension versus the premium.
Absolutely.
Right? Like get the O-1 extension in the door and always maintain your lawful status.
Let's do some questions.
Okay. You had a thank you here, and I wanted to show it to you.
Julian, Hill Burrito made our entire process
smooth. You said Gil. Why did you reread your own name?
That's how the gringos call me Hill.
It's Gil, guys.
It's Gil Burrito made our entire process smooth and stress-free and truly went above and beyond. If you're thinking about hiring an immigration attorney, look no further. They're simply the best. Julian, thank you very much. I appreciate that, my friend. Thank you. Thank you. Let's go here. Instagram. Carla, Tropical Show. Hola, amigos. I'm gonna green gullet for you. Hi, friends. I want to know if right now is a good time of start thinking about the American dream. Una visa or is there a, you know, likely that we could obtain a work visa? I'm a Spanish citizen, originally from Venezuela. The American dream is, gosh, alive. I would say
alive and well,
and it's going to continue being alive and well. It's just, listen, I've said this for many years. America sells itself. I don't have to sell America. Like being here. Listen, is there better places? Sure there are. I'm sure. You know, can you have a quieter, more peaceful life somewhere else? You're not afraid of, like, you know, ICE hunting you down and this type of stuff. Like, yeah, I'm sure. Is it sometimes not easy financially in the U.S.? It's a very expensive place to live in certain parts. And, you know, but I still believe that opportunity is here.
There's no other place where you can make more money.
That's the truth. I just don't know. I mean, I guess like places like Dubai, maybe, if you're like a crypto king or something, you know what I'm saying? If you're in the, if you're like in the 0.0, no, places that don't have an income tax, I guess,
right.
You know what I'm saying? Like you're in the 0.01% of people in the world. But I would say most people, since I started doing this, are really, really actively trying to get to the US. And it's not just for yourselves. Generally, most of them will tell you it's for my kids in the future, and I'm doing this for them. I spoke to people this morning. They're like, Gil, if it was up to me, I would stay in so and so country, to be honest with you. But I'm trying to do it for my 3 girls, and they're of the age that I want them to do their school in the US and go to college and have kind of a life that's different from the one that I have, you know. That's why. So I do believe it, Carla, that yes, I do believe that is alive. It's still very possible. We're getting visas approved every day. We're getting green cards approved every day. I know things look scary, and they are scary in some situations, and they are. And it makes me feel horrible that people have to go through some of these situations. But I wouldn't say that is the norm across everybody. Like that's just not true. It's not happening, you know?
Eliam actually asked me a question that's directly on point. Send you an email. Okay, Eliam, I'll take a look. I was looking into EB-3, but after our meeting, I think O-1A could be a better path for my situation. It just worries me my profile might not be good enough. So Eliam, it could be the case that I didn't mention O-1A or we didn't discuss O-1A because of precisely that. During our consultation, maybe I saw that O-1A wasn't the right way and we were doing labor certification. But that being said, obviously I'll answer your email now, but I'll sort of start it up here. What you can do is you may want to consider starting the PERM already, because the PERM process takes approximately 3 years, and simultaneously going for the O-1, which is what's going to allow you to wait out the time of the labor certification here. In cases of labor certification, that's one where if you have the ability, I would jump the gun as quickly as possible. And I would start it because the clock is so long. Because it's a 3-year clock, I would start that process right away. And then during the meantime, you go What you're saying, where your profile might not be enough, you go building your profile. And then let's say in 6 months, you're able to apply for the O-1A, you're able to come in here and basically wait out your labor certification here. What you don't want to do is do this work to put together an O-1A and then, okay, once I'm in the US, I'll submit a labor certification, because inevitably you will must renew your O-1. So it may be in your situation that you want to do the PERM first, then the O-1A. But yeah, we can certainly build up your profile.
Good afternoon from Wayne. Would it be difficult to get approved for an EB-3 through the consulate if someone has had TPS and has been in the US for 10 years legally without asylum in general? With that fact pattern, I see absolutely no issues as long as they're not admissible to the United States and never been illegal in the United States and they weren't just awaiting an asylum, meaning that they had a non-immigrant visa status, Wayne, throughout their entire time here. No, absolutely not. We could definitely do an EB-3 through the consulate. Now, I'm assuming they're Venezuelan because of TPS. If that is true, then just keep in mind there's no immigrant visas being issued at the consulate currently, and EB-3 cases, I-140s, are currently suspended and paused because Venezuela is one of the 19 countries in the December 19 country ban. As me and Stephanie were discussing previously, they are not included in the 75 country ban.
So like,
which is kind of like, but Cuba is, which you mentioned, which we don't know what's up with that.
So confused. But what I was going to say is hopefully he has non-immigrant status now.
Oh, yeah.
Right. So hopefully.
Well, it says U.S. for 10 years legally. Oh, man. Great point. Do you have legal status today?
Do you have it now?
So if you had it after November 7th, 2025, when TPS ended, fantastic. If not, and you left the U.S. in a timely fashion, you're still going to be okay as long as you left the U.S. within 180 days of November 7th, which the clock is ticking. For all those people that previously were on TPS, be careful because very soon you're going to be past 180 days.
You know how you were asking me while we were having that conversation earlier, well, are other countries from the 19 and then I was doing the cross check now, and yeah, they are. The only one that didn't make it on is Venezuela. Isn't that bizarre?
I don't think it's bizarre. I think
really?
I think it's by design.
Oh, you think it was purposeful?
Yeah, I think it's design. Yeah, and these people don't. I don't know.
Yeah, almost all of them. That's odd.
Yeah.
What are they cooking up?
I think Venezuela's situation
Something's cooking up.
is going to improve.
Yeah,
I feel the excuse me, the visa situation.
Yeah, of course.
The visa situation.
All right, let's see. Hey, Tropical Lawyers, Andrea. Curious if you're seeing the same or worse results with O-1 visas these days. Is premium processor riskier than regular processing, or does it affect the outcome? Honestly, I haven't had any issue with premium processing on O-1s at all.
No.
And I'm having generally the same results. This goes a little bit to what we were speaking earlier. There was some issues with change of statuses from things like TPS, but honestly, it was because of only a lack of awareness and education on the part of the officer. But that was only, and it's a very minute group that was subjected to that. Everyone else who has generally normal situations, maybe they're applying for O-1 through the consular, maybe they're changing O-1 from a previous F-1, for instance. I really haven't seen any sort of change as far as the adjudication, as far as the approvals. They continue to be a phenomenal case. That's why we do the O-1s, because we really believe in them. Our formula really works. And it's one that tends to not be affected by presidential changes
or
by administration
other
changes.
issues, like other categories being denied, like EB-2 NIW or EB-1 or
O-1
what.
is consistent.
Yeah, it's consistent. It's a great visa classification. I'm happy that I kind of picked that as my bread and butter many years ago.
Happy I followed you in there.
But I will say, I almost feel you have to do premium for an O-1 right now.
Oh,
the processing times, the wait time. I checked on it, I don't know, a few days ago. 9.5 months.
That's crazy.
It popped to 9.5 months. And that's, remember, that's what they're stating.
Right.
When they state 9.5 months, it's a year.
Yep.
Like, that's the reality. So is that reasonable for like an employer to wait for you to work, for productions to be taken? No, unfortunately they've done it. So O-1 is almost obligated to do a premium processing. Premium did go up slightly, $2,965. March 1st, I guess.
March 1st.
March 1st.
Yep, March 1st.
So, I always talk about in terms of 3,000. Now it's literally almost 3,000. So it's, I think, a good investment. I am not convinced premium processing is a good investment in every type of visa classification and every green card application. And, gosh, I don't think my opinion has changed more over the years on anything other than premium processing this much. Like it changes on a regular basis. Right now, in the current climate, yes, O-1 premium processing, I basically think you have to do it. Is it me?
Yep.
So I'll tell Vinicio Antonio, you're very lucky because I've done a ton of G4 research recently. I got a G4 visa, which is the best option for me after this visa, EB-1 or EB-2 NIW. We have to take a good look at your case. How many years you were on that G4 might be interesting for you, because depending on how many years you were on the G4, and if I'm correct, there's a 7-year
I'm pretty confident it's
law, that says, regulation that says, as long as you serve, for example, in the World Bank or whatever, NATO or whatever reason that you have your G4, if you've served for at least 7 years and you're not inadmissible for any other reason, and you comply with with all the requirements of 245A to adjust your status, there is a process of filing a special immigrant petition. I believe you do it through the form I-360 for the G4. I was researching the fact of G4 of adjustment of status for my client, which is via my research, I've come to the conclusion, which is perfectly fine to do in the United States. But a lot of the information out there, especially Vincenzo, if you're doing Vinicio, if you're doing things like ChatGPT or whatever, it's gonna all be about you filing the special immigrant visa,
right?
And going down that rabbit hole for it. Not an EB-1 or an EB-2 NIW, but yes, you could do potentially an EB-1, EB-2 NIW. If we could do an EB-1, beautiful, my preference. If not, probably an EB-2 NIW.
I did a G4 to an EB-2 NIW, successful. I had done that research. It was such a nightmare because it's true. It's all about the special immigrant. I remember the 7 years too, but check this out. It's 15 years for the actual employee, 7 years for the family. That's why we were remembering the 7 years.
Oh, there it is. Man, I almost said, I think it's seven. I think 7 for one and like 15 for the other. Okay.
15 years as an actual officer because G4, for those that don't know, is like NGOs.
Yeah.
UN, World Bank, IDF, for instance. So 15 years of work as the G4, but the family could do only 7 years. FYI.
Okay. So probably Vinicio is not in the 15-year.
I mean, maybe.
Probably not.
Look at him. You don't think that man has 15 years on him?
No, man.
No, he looks young.
He's a young guy, man.
Young guy.
Yeah. He's a young guy. He'll probably go the EB-1, EB-2 NIW route. Let's go with
EB-1 self-petition.
Go ahead.
NVC says financial documents are missing, but the section was never enabled in SEAC. I understand it doesn't apply. That's correct. Should I do a public inquiry or wait for them to continue the review? I would do an Ask NVC. I would do the public inquiry form, and I would be like, hey, listen, I've received a correspondence that indicates that financial documents are not available. Please note that I'm qualifying under EB-1 self-petition, and I do not have to provide financial documentation. They typically respond to Ask NVC within the week. Honestly, shorter. They typically respond within 48 hours. So you'll get a response very quickly. Here's my thing, though. I'm very confident. I would like to know if you think this too, that Ask NVC has started using ChatGPT and bots to respond. I'm like 99% confident in this because
NVC does a great job responding to me.
Here's the thing. Ask NVC. I've done this. Like I've been in these situations where they're asking me stuff and I'm like, I send an email and I'm like, no, you don't need this stuff. And they're like, okay, but send it to us. And I'm like, no. And so after doing it like 3 times to Ask NVC, and you have to spell it out really basically, I do not need this EB-1. They're like, oh, okay.
Maybe they're using like AI within their some sort of tools for that. That's kind of generating responses.
I'll give you an example. Okay. they wouldn't give me the fee bill. This is the one I've been fighting and I'm like convinced. They wouldn't give me the fee bill for the kid, which we calculated with a CESPA. 100% he was good. He's 21 now, but he was good to go. And they're like, okay, well, we don't think he qualifies. And I was like, just send me the fee bill because sorry, I'm totally going on a tangent here.
Go ahead.
ask NVC, or excuse me, NVC does not make the CESPA determination. The consular officer makes the CESPA determination. That is very, very important because NVC could say, no, CESPA doesn't apply. And you still have to be like, give me the fee bill. I'm going to pay. I want the officer to look at this. And you take your CESPA calculation to the officer, and the officer will usually give it to you if it
Is
qualifies.
that by regulation? Is there like
100%.
a reg that says
I looked
that?
it up like 3 days ago.
That's good.
Consular officer makes a determination. So we had to like ask NVC like 4 times.
Yeah.
But anyway,
Let them deny
do
it.
it.
Let them deny it.
do it.
Yeah.
And they will eventually be like, oh,
Jesus.
my bad. Sorry, I've removed the financial documents. Sorry, I really went on a tangent there.
Moises, hello, dear Troppies. What signs are you seeing about when the visa pause for Colombians might be lifted? Nothing soon, to be honest with you, Moises. I just don't, I haven't seen anything about this. They put the ban in. What did they say? Every 90 days for that ban? That one's 90 days or 6 months?
Did it say?
Okay, maybe I'm wrong. Maybe they didn't even give a time frame. I thought somebody told me that it was 90 days, that they would be looking into it again. But basically, they're giving themselves a time period to create the public charge policy or regulation that's going to be applicable by the Department of State for consular interviews. So as to your question, what real changes do you expect EB-1A consular interviews after that? The good news is you're an EB-1A. The bad news is they might want to see evidence that you're not going to be a public charge. What type of evidence is that? You have a bank account that has some money in it. You know, maybe you have a house in the US. Maybe you have property in Colombia. You know, you don't have any debt. There's a lot of things they could take into consideration. Maybe they're going to ask you for your Colombian tax returns. You know, there's a lot of things that could, like if you're in the US, they'd be asking you for all the US stuff. You know, US bank account, property. Are you currently employed? Are you working? You know, so I would say specifically, Moises, in your case, I don't think you're going to have to worry about very much, to be honest with you. But once that information comes out, which I do expect it to be rather soon, this is the thing. I believe they're going to try to roll the consular into what USCIS is doing with the public charge. So USCIS is coming out with public charge guidance probably in the month of March, because I think they set a 60-day period and that was in January. So more or less in the month of March at some point. And I think they're going to roll that and put it across the board for the consulates as well. We'll have more information soon on that, I think.
To your 90 days. It's what we were talking about before the show. They've done so many different immigration ban, pause, It's the one that's the 90 days was the pause on asylum applications.
Okay.
So they have to reevaluate that and they have to provide that in 90 days. But the 75 countries doesn't. But we did generally think it was going to be 90 days because of the public charge thing.
Oh, I'm sorry.
But it's not official.
You know what happened to me today? I received 3 appointments for Bogota for Colombians.
Oh, I got 2.
Immigrant visas.
Way.
I received 3 appointments for Bogota immigrant visa. So what I heard, what could be happening, because this is what happened to Venezuelans, is they would go to the interview and they just wouldn't issue the visa.
I literally got it like right before the show, so I didn't even have time
I got
to
a whole
look at
bunch.
it.
Yeah.
But I got 2 just now before the show.
Yeah, it surprised me.
You're right.
Yeah.
So they're going to have them go, but just not issue the immigrant visas.
I think that's what's going to happen because they don't want to get too backed up, I think.
Which to your point, that means they're going to lift this soon. Because they wouldn't be, internally, they wouldn't be wasting their time if they weren't going to lift this soon.
Oh, I also have I got some goods.
What do you got?
I got some inside info.
What inside info?
U.S. Consulate, Caracas. Goal, summer.
No. Where'd you get that?
Yeah, good source.
No way.
Good source of info.
You think?
Yeah, good source of info. You're not going to find it online, by the way.
Damn. You do have contacts.
You're not gonna find that online. And that I said it. I knew it. I thought it was gonna be later in the year.
Say it.
I thought it was gonna be later in the year or early next year. To be honest with you, they're really pushing it hard to open quite quickly, which is gonna be good. Anyway, sorry to throw that in there. Should I just roll through these? Gosh, there's a lot of questions today. Okay, we talked too much about our theme of the day.
All right, hold on. Let's go. We got it.
Here's Betty. For my travel and work needs, is AOS or consular cleaner? If you need to travel, consistently from the United States during a green card process, and you don't mind, and you have a non-immigrant visa to enter in and out, and you don't mind processing it through the U.S. consulate, potentially taking longer in some instances, not others. Is it cleaner? It is cleaner for you individually. Now, do your work needs in the U.S. supersede that to the point that you need a work authorization in the U.S. based on the adjustment of status? Well, that's different. Then maybe you want to have a plan where you're applying for a travel document. Travel documents are taking forever, Betty. I'm of the opinion that I probably, I try to guide my clients to do that type of case consular. I'll just give you an example. A very typical client that we do is a musical artist that's on tour globally. They can't spend 6 months, 9 months waiting for an adjustment of status in the US. They need to travel. The travel documents are being pretty much arbitrarily approved, or emergency travel is arbitrarily approved. I'm of the opinion that that case must be consular.
Yep. Let's see. Ricardo has an interesting question. I don't really know how to answer it. Is there any way to know if my employer is delaying the EB-3 process so that I can continue working for them? So look, if you know that they started the EB-3 process, there's nothing, I'm going to be honest with you, there's not really a way for them to delay it because everything has expiration dates. So you're going to first get a prevailing wage determination from the Department of Labor. Prevailing wages are given them in about, I don't know, like 5 months right now. And they'll give you the prevailing wage. Then you have a 60-day reclutamiento. I just translated directly. A 60-day recruitment period, right? And so you're going to do that, and that can go up to roughly 90 days. But you have to start and file the labor certification within 6 months. So because of all those expiration dates, I'll be honest, there's not really a way for your employer to delay the process once it started going. As long as it started going, you can generally be sure that it's continuing as long as the prevailing wage has been filed, because there will be an expiration date for the labor certification. There will be an expiration date for the ads. After the labor certification is certified, then you have to file the I-140, also typically within a certain amount of time, right? I mean, not necessarily, but you do have to essentially present this. And I would say don't be too concerned. Just be sure that at least the prevailing wage has been filed, because after that, it's going to be smooth sailing.
I was just laughing at Jasper. Jasper's question's excellent. Serious immigration question. Do the attorneys root for the Patriots or the Seahawks? Listen, man.
At the Bad Bunny concert?
No. Asking for a green card. Patriots, man.
Yeah, it's 100% Patriots.
We got to go Patriots.
Yeah.
Let me tell you, not a Seahawks fan, never been a Seahawks fan, never been a Patriots fan, to be honest with you.
Dolphins, so we can't. Well, no, you're not. You're not.
I'm not a Dolphins fan.
You're not.
I'm a Chicago Bears fan.
Yeah.
And I was a one-time Tampa Bay Buccaneers fan for many years when I lived in Tampa. But I'll tell you, it's going to be Patriots.
The Patriots aren't going to win.
It's going to be Patriots. I just feel it.
At the Bad Bunny concert.
Organization is so good.
Boston,
the
baby.
Organization is so good that they're able to come back from everything they did, and now they're in it again. It blew my mind. I'm like, I can't even believe these guys. Hey, they're going to take it. Plus, playing in all that snow, come on.
Only they can.
You got to do it. You got to do it. Fernandito, if I do a change of status of O-1 in the United States, do I get my visa issued in the passport here? No, you do not. It's a really important distinction. Who issues a visa? Only a U.S. consulate abroad is able and has the ability to issue a visa. Why? Because they're doing certain amounts of security checks. They're doing other things. They're going way beyond just seeing if you qualify for a visa. Okay. If you do a change of status in the United States, you get O-1 status for 3 years. Now that means you could be in the US for 3 years. You could be working here for 3 years, or you could immediately, or take some time, travel, make an appointment at the US consulate of your home country abroad. Okay. Or a country that you have nationality of. And you're able to go ahead and have an interview at that consulate, and then they will issue the visa. You cannot have a visa issued in the United States. Steph, when I started as an attorney, you did.
Really?
You could. So what we would
Where
do,
would it get stamped?
I was a young lad.
Young lad. Seriously.
With no beard.
Over 11 years ago.
What are you talking about?
Well over 11 years ago.
23 years ago.
Okay. Yeah.
So what you would do is, this is like my first year, you would get the approval notice, and then you would get the person's passport and the approval notice, and you send it to a consular section in Washington, D.C., and they would physically issue the visa in the passport.
No way.
And they would do that.
I'm learning something.
That was like a thing, you know what I'm saying? And then there was some mumblings about it during the Biden administration that they were considering going back to that to make it more efficient. The reason I don't agree with that is it is from a security standpoint, and I think the proper officer to adjudicate a visa should be the consular officer from a security. A lot of things changed post 9/11, right? So post 9/11, all these things changed, and they put in all these efforts and they made all these changes. I'm not saying it's the best way, but it's an efficient way, you know? So they would have your passport and your visa, and then they would send it back to you. And there was a ton of service providers in Washington, D.C. that would facilitate happening. Like if you needed like expediting, there was like a whole thing. That was like a whole, I remember. But no. Currently,
what are those people doing nowadays?
You can
What are those people doing nowadays? All those service providers.
Medicare fraud.
Oh my God.
Who knows? They got a Somali daycare up.
Going with Lois. Lois Cabral. I'm currently on an F1 LLM student entering OPT, licensed attorney abroad with over 4 years of U.S. immigration paralegal experience. What realistic options do I have for permanent residence beyond the H-1B, such as EB-2 or other pathways? For permanent residency, remember H-1B doesn't lead to permanent residency. It is a temporary visa, 3 years and 3 years, and you could potentially expand it after 6 years with the filing of another petition. H-1B is a very, very logical route. O-1A could potentially be a route, but I'll discuss it now. I do not like EB-2 for attorneys. For just a practicing attorney, I do not like it because many of the arguments are essentially going to be, okay, what are you going to do? Come and work in law in the US? That's not a good national interest argument, right? And plus, it's an industry that is very oversaturated in the United States. If you're a lawyer and you want to work on that and you want to utilize that experience for an EB-2, go more the research and investigator route. Listen, I'm a specialist in this type of transactional law that affects these two types of the countries. I've written books about it. I've written law review journals about it. I've written, all these sort of articles, and I've been cited many times. I've been invited to speak on panels by the ABA about this topic. You have to go the research investigator route. That's going to be a much, much, much stronger EB-2 than simply I'm going to practice law in the United States. Because if you just say I'm going to practice law in the United States, they're going to tell you do a PERM. You're going to fail on the waiver portion of it.
You should do a PERM.
PERM is the way, right? The route is
PERM.
F1 OPT, H1B, PERM. That's the cleanest way.
Yeah.
But if the way she's kind of wording it is, can I do an EB-2? Maybe she doesn't have the PERM sponsor.
I've done EB-2 and NIW for somebody that has a very exceptional law background, that was like an expert in mediation. But when I mean an expert in mediation, president of the association.
That's how
you know what I'm saying?
Yeah.
Works for an American law firm outside of the US for multiple years, going to continue working with the American law firm here in the US, specifically doing like CLE programs for international mediators. Like it was just like, she really was,
stand out.
She really was quite incredible. I agree with you 100%. I think lawyers are tough.
Lawyers are tough.
Lawyers are tough.
To just say, I'm going to practice law.
Yes.
But if you could say I was the, like you're saying, the president of the board, the president of the association of mediators of this country, that's different.
Let's go. Oh, Vinicio's like, I got my visa yesterday, dude. He's like, the G4? I've had it for 2 minutes. I've had it for 2 minutes and I want a green card.
A lot to do, friends.
Vinicio, EB-1, EB-2, do it, dude. Where we got King Sam Chang. Es mi segunda visa, uno con ustedes. Second visa. Can I do a third one? Come on, man. Of course you can.
I tried. This is going to be a little plug. I tried Daikin Asian because of King, and it was delicious.
Whoa.
King, I totally remembered.
Whoa.
What
is this? What is this?
Whoa, that's crazy.
What is this? This is a young
Michael Scott.
Young Michael Scott from The Office. It really was like The Office, to be honest with you.
All right, so hold on. King had some follow-ups.
Please.
He did his O-1 with us, yes, and he's a wonderful chef.
Yes.
And I want to start my EB-1, but it's true, Venezuelans currently have a pause. So yes, so basically, King, currently they're not really adjudicating petitions. Mind you, we're still getting decisions, but they're far later and they're taking far longer. And for some, they're just an eternal perpetuity waiting, right? So you do need to extend the O-1 because of your Venezuelan background. Dual nationality doesn't cure that. So inevitably, yes, you 100% have to extend the O-1, but you can file the EB-1. So at least you're in the door, right? So you may want to consider doing the O-1 extension and filing the I-140 of the EB-1 already with regular processing.
That was funny. He got his G4 so quickly.
Yeah.
He's like, I mean,
So
just
I got it
recently.
yesterday.
Thank you, Lucas. Gil and Stephanie, you are the best.
Yeah.
Come on, man. We're trying to do it for the English show. Like. Really good one. Edgar. If your petition is pending while you wait in the US for a decision, are you accumulating illegal time or illegal presence, or are you allowed to wait in the country? I have a pending O-1 visa petition. So as long as you were in lawful status as long as you were in lawful non-immigrant visa status prior to filing that O-1 petition, and the case is pending, and it took the time that it took. It took, whatever, 6 months, a year, you didn't do premium, or premium is paused for you, or if you're Venezuelan and there's no final decisions on your case, or whatever it might be. Now, are you accumulating unlawful presence? No, you are not. Okay, you are not. You have what's called authorized stay by the Attorney General. It is true that it is the discretion of the Attorney General, DHS, to withdraw that. And it is true. Just because it's something where I'm protected because I have a case that's pending. Yes and no. Yes, you are protected. But the law clearly states, Stephanie, and interrupt me, please, if I'm wrong, that that is at their discretion. And generally, they provide favorable discretion to people that have non-immigrant visas pending, or green card pending, or whatever type of case pending.
If it's purely discretionary, is your question?
It's not purely discretionary. They have the discretion, and this is in the law. Okay. Just because you have authorized stay by the Attorney General does not mean they cannot revoke that authorized stay, even though your case is still pending with USCIS.
What would they have to do in order to revoke it? Send a correspondence? Yeah. I've never seen that situation.
So never happened to me, but as a student of the law, I'm like, hey, and I don't like to talk and speak in
absolutely.
That was like a little New Yorker there. You heard? Like, I don't want to talk.
I don't want to talk.
I don't want to talk. So I'm not from New York. So
he just said he's a Bears fan.
I don't want to be in a situation where my client is relying on me telling them, hey, by the way, there's absolutely nothing to worry about. I always say it with a caveat. Well, I mean, look, there's nothing to worry about. It's never happened to me. I've never had this situation. Is it impossible for ICE to stop me, ask me questions about it? I get into the situation. It's not common. And it's very, very unlikely that'll happen to you, but it's not impossible. Like, I know where his question's going. Like, am I authorized to remain in the U.S. during the time? Yes, you are. Okay, you are authorized currently until that authorization is taken away from you.
And you would know.
You'll know.
You would know if for whatever reason.
Hey, you know what I got? I got to show it to you.
What?
U.S. Department of Homeland Security wrote me a little letter. The old Gil Brito himself.
No. What? Why are we in trouble? What's happening?
You're not in trouble.
Thank goodness. Woo!
They wrote me a letter and sent it to my home address.
No.
My wife's like, hey, are you getting deported? I'm like, no, I don't think so. It's a thick letter too. It's a whole thick letter, whatever. My son orders something on Amazon.
Oh, yeah.
And it's something to do with some technology thing. And the technology thing apparently is in violation of U.S. communication laws to intercept communications. This is my 13-year-old son.
Who ordered a product from China.
From China. On Amazon. On Amazon. You ordered on Amazon. By the way, so they sent me a letter. By the way, if it wasn't me dealing with these guys for so many years, if I'm somebody that gets this letter, I would be scared. I'll be honest, I would be scared. I was laughing. Part of me wants to like file a federal lawsuit against them for being so ridiculous that we bought something lawfully
Also, sue Bezos.
on a platform. And this platform, by the way, I got on it with Amazon. Like, what the hell are you people doing? So this has been a thing. They canceled my global entry. Okay. They canceled me, my global entry. I'm like, okay. And I didn't know why they canceled my global entry. So I was like, what the heck is this? I'm like, please, like trying to get it reinstated and all this stuff or whatever. It didn't respond to me. Now I get this letter, a 5-page letter saying, what do you want to do? If you choose to go ahead and file a hearing for it or whatever, we'll refer the case to the U.S. attorney. I'm like, okay, dude, like what? Like, this is something that's
like,
gonna,
of all
like,
people.
do I have to like hire a lawyer now? like what is happening? You know what I'm saying? One of the options, like, you could abandon the property and we'll close it. And I'm like, obviously that's what I'm gonna do.
But is that gonna reinstate the global entry?
Probably not, because I went ahead and abandoned it. I'm like, what? I don't even care about the global entry at this point. But anyways, I'm just letting you know, Edgar, if the US government wanted you to know what was up, you'll know what was up, as to Stephanie's point. Okay. And just sharing a little fun personal anecdote.
Long-winded way to get there, but I do love it. That's right.
I think it's the end of the show.
I'll do one more
really
quick.
Give it.
EDAV, Venezuelan and Brazilian. My I-751 has been pending 2 years, 3 months. Is my case on hold? While it could potentially be on hold because you're Venezuelan and dual nationality doesn't get you out of that presidential proclamation, it probably is just within normal processing times. I-751 is the case that's currently taking the longest. Official posted times are 2 years and 3 months, 27 months. So don't worry, just keep waiting. It could be, in fact, that they take a while longer because you're Venezuelan, but it's technically within normal processing times.
I would say probably on hold, but maybe not.
Like possibly on hold, but don't think the 2 years and 7 months is your hold.
2 years and 3 months is nothing for an I-751.
Yeah, that's normal.
Wow, it got deep. The English show, keeping it real.
The global entry was crazy. Pausing it for an immigration attorney.
See you guys.